Please subscribe, like, and share this video. Thank you for your support.
2 U.S. Code Chapter 26, Disclosure of Lobbying Activities. 2 U.S. Code Paragraph 1601, Findings. The Congress finds that 1. Responsible representative government requires public awareness of the efforts of paid lobbyists to influence the public decision-making process in both the legislative and executive branches of the federal government. 2. Existing lobbying disclosure statutes have been ineffective because of unclear statutory language, weak administrative and enforcement provisions, and an absence of clear guidance as to who is required to register and what they are required to disclose. And 3. The effective public disclosure of the identity and extent of the efforts of paid lobbyists to influence federal officials in the conduct of government actions will increase public confidence in the integrity of government. 2 U.S. Code Paragraph 1602, Definitions. As used in this chapter. 1. Agency. The term agency has the meaning given that term in Section 551(1) of Title V. 2. Client. The term client means any person or entity that employs or retains another person for financial or other compensation to conduct lobbying activities on behalf of that person or entity. A person or entity whose employees act as lobbyists on its own behalf is both a client and an employer of such employees. In the case of a coalition or association that employs or retains other persons to conduct lobbying activities, the client is the coalition or association and not its individual members. 3. Covered executive branch official. The term covered executive branch official means A. The president, B. The vice president, C. Any officer or employee, or any other individual functioning in the capacity of such an officer or employee in the executive office of the president. D. Any officer or employee serving in a position in Level 1, 2, 3, 4, or 5 of the executive schedule, as designated by statute or executive order. E. Any member of the uniformed services whose pay grade is at or above 7 under Section 201 of Title 37, and F. Any officer or employee serving in a position of a confidential, policy-determining, policy-making, or policy-advocating character described in Section 7511, B. 2b of Title V. 4. Covered legislative branch official. The term covered legislative branch official means A. A member of Congress, B. An elected officer of either House of Congress, C. Any employee of, or any other individual functioning in the capacity of an employee of 1. A member of Congress, 2. A committee of either House of Congress, 3. The leadership staff of the House of Representatives or the leadership staff of the Senate, 4. A joint committee of Congress, and 5. A working group or caucus organized to provide legislative services or other assistance to members of Congress, and D. Any other legislative branch employee serving in a position described under Section 13101(13) of Title V. 5. Employee. The term employee means any individual who is an officer, employee, partner, director, or proprietor of a person or entity, but does not include A. Independent contractors, or B. Volunteers who receive no financial or other compensation from the person or entity for their services. 6. Foreign entity. The term foreign entity means a foreign principal, as defined in Section 1b of the Foreign Agents Registration Act of 1938, 22 U.S.C. 611, b. 7. Lobbying activities. The term lobbying activities means lobbying contacts and efforts in support of such contacts, including preparation and planning activities, research and other background work that is intended, at the time it is performed, for use in contacts and coordination with the lobbying activities of others. 8. Lobbying contact. A. Definition. The term lobbying contact means any oral or written communication, including an electronic communication, to a covered executive branch official or a covered legislative branch official that is made on behalf of a client with regard to 1. The formulation, modification, or adoption of federal legislation, including legislative proposals. 2. The formulation, modification, or adoption of a federal rule, regulation, executive order, or any other program, policy, or position of the United States government. 3. The administration or execution of a federal program or policy, including the negotiation, award, or administration of a federal contract, grant, loan, permit, or license. Or 4. The nomination or confirmation of a person for a position subject to confirmation by the Senate. B. Exceptions. The term lobbying contact does not include a communication that is 1. Made by a public official acting in the public official's official capacity. 2. Made by a representative of a media organization if the purpose of the communication is gathering and disseminating news and information to the public. 3. Made in a speech, article, publication, or other material that is distributed and made available to the public, or through radio, television, cable television, or other medium of mass communication. 4. Made on behalf of a government of a foreign country or a foreign political party and disclosed under the Foreign Agents Registration Act of 1938, 22 U.S.C. 611 etc. 5. A request for a meeting, a request for the status of an action, or any other similar administrative request, if the request does not include an attempt to influence a covered executive branch official or a covered legislative branch official. 6. Made in the course of participation in an advisory committee subject to Chapter 10 of Title V. 7. Testimony given before a committee, subcommittee, or task force of the Congress, or submitted for inclusion in the public record of a hearing conducted by such committee, subcommittee, or task force. 8. Information provided in writing in response to an oral or written request by a covered executive branch official or a covered legislative branch official for specific information. 9. required by subpoena, civil investigative demand, or otherwise compelled by statute, regulation, or other action of the Congress or an agency, including any communication compelled by a federal contract, grant, loan, permit, or license. 10. Made in response to a notice in the Federal Register, Commerce Business Daily, or other similar publication soliciting communications from the public and directed to the agency official specifically designated in the notice to receive such communications. 1. Not possible to report without disclosing information, the unauthorized disclosure of which is prohibited by law. 12. Made to an official in an agency with regard to 1. A judicial proceeding or a criminal or civil law enforcement inquiry, investigation, or proceeding, or 2. A filing or proceeding that the government is specifically required by statute or regulation to maintain or conduct on a confidential basis, if that agency is charged with responsibility for such proceeding, inquiry, investigation, or filing. 13. Made in compliance with written agency procedures regarding an adjudication conducted by the agency under Section 554 of Title V or substantially similar provisions. 14. A written comment filed in the course of a public proceeding or any other communication that is made on the record in a public proceeding. 15. A petition for agency action made in writing and required to be a matter of public record pursuant to established agency procedures. 16. Made on behalf of an individual with regard to that individual's benefits, employment, or other personal matters involving only that individual, except that this clause does not apply to any communication with 1. A covered executive branch official, or 2. A covered legislative branch official, other than the individual's elected members of Congress or employees who work under such members' direct supervision, with respect to the formulation, modification, or adoption of private legislation for the relief of that individual. 17. A disclosure by an individual that is protected under the amendments made by the Whistleblower Protection Act of 1989, under Chapter 4 of Title V, or under another provision of law. 18. Made by 1. A church, its integrated auxiliary, or a convention or association of churches that is exempt from filing a federal income tax return under paragraph 2(a)(i) of Section 6033(a) of Title 26, or 2. A religious order that is exempt from filing a federal income tax return under paragraph 2(a)(3) of such Section 6033(a) and 19. Between 1. Officials of a self-regulatory organization, as defined in Section 3(a)(26) of the Securities Exchange Act, 15 U.S.C. 78 (a)(26), that is registered with or established by the Securities and Exchange Commission as required by that Act, 15 U.S.C. 78 AET-SEC, or a similar organization that is designated by or registered with the Commodities Future Trading Commission as provided under the Commodity Exchange Act, 7 U.S.C. 1 ET-SEC, and 2. The Securities and Exchange Commission or the Commodities Future Trading Commission, respectively, relating to the regulatory responsibilities of such organization under that Act. 9. Lobbying firm. The term lobbying firm means a person or entity that has one or more employees who are lobbyists on behalf of a client other than that person or entity. The term also includes a self-employed individual who is a lobbyist. 10. Lobbyist. The term lobbyist means any individual who is employed or retained by a client for financial or other compensation for services that include more than one lobbying contact, other than an individual whose lobbying activities constitute less than 20% of the time engaged in the services provided by such individual to that client over a 3-month period. 11. Media organization. The term media organization means a person or entity engaged in disseminating information to the general public through a newspaper, magazine, other publication, radio, television, cable television, or other medium of mass communication. 12. Member of Congress. The term member of Congress means a senator or a representative in, or delegate or resident commissioner to, the Congress. 13. Organization. The term organization means a person or entity other than an individual. 14. Person or entity. The term person or entity means any individual, corporation, company, foundation, association, labor organization, firm, partnership, society, joint stock company, group of organizations, or state or local government. 15. Public official. The term public official means any elected official, appointed official, or employee of a federal, state, or local unit of government in the United States other than 1. A college or university. 2. A government-sponsored enterprise, as defined in Section 622(8) of this title. 3. A public utility that provides gas, electricity, water, or communications. 4. A guarantee agency, as defined in Section 1085(j) of Title 20, including any affiliate of such an agency, or 5. An agency of any state functioning as a student loan secondary market pursuant to Section 1085(d)(1)(f) of Title 20. B. A government corporation, as defined in Section 9101 of Title 31. C. An organization of state or local elected or appointed officials other than officials of an entity described in Clause 1, 2, 3, 4, or 5 of subparagraph A. D. An Indian tribe, as defined in Section 5304(e) of Title 25. 1. E. A national or state political party or any organizational unit thereof, or F. A national, regional, or local unit of any foreign government, or a group of governments acting together as an international organization. 16. State. The term state means each of the several states, the District of Columbia, and any commonwealth, territory, or possession of the United States. 2 U.S. Code paragraph 1603, registration of lobbyists. A. Registration. 1. General rule. no later than 45 days after a lobbyist first makes a lobbying contact or is employed or retained to make a lobbying contact, whichever is earlier, or on the first business day after such 45th day if the 45th day is not a business day, such lobbyist, or, as provided under paragraph 2, the organization employing such lobbyist, shall register with the Secretary of the Senate and the Clerk of the House of Representatives. 2. Employer filing. Any organization that has one or more employees who are lobbyists shall file a single registration under this section on behalf of such employees for each client on whose behalf the employees act as lobbyists. 3. Exemption. A. General rule notwithstanding paragraphs 1 and 2. A person or entity whose 1. Total income for matters related to lobbying activities on behalf of a particular client, in the case of a lobbying firm, does not exceed and is not expected to exceed $2,500, or 2. Total expenses in connection with lobbying activities, in the case of an organization whose employees engage in lobbying activities on its own behalf, do not exceed or are not expected to exceed $10,000. As estimated under Section 1604 of this title, in the quarterly period described in Section 1604A of this title during which the registration would be made is not required to register under this subsection with respect to such client. B. Adjustment. The dollar amounts in subparagraph A shall be adjusted. 1. On January 1, 1997, to reflect changes in the Consumer Price Index as determined by the Secretary of Labor since December 19, 1995, and 2. On January 1 of each fourth year occurring after January 1, 1997, to reflect changes in the Consumer Price Index as determined by the Secretary of Labor during the preceding four-year period, rounded to the nearest $500. B. Contents of registration. Each registration under this section shall contain 1. The name, address, business telephone number, and principal place of business of the registrant, and a general description of its business or activities. 2. The name, address, and principal place of business of the registrant's client, and a general description of its business or activities, if different from paragraph 1. 3. The name, address, and principal place of business of any organization, other than the client, that A. Contributes more than $5,000 to the registrant or the client in the quarterly period to fund the lobbying activities of the registrant, and B. Actively participates in the planning, supervision, or control of such lobbying activities. 4. The name, address, principal place of business, amount of any contribution of more than $5,000 to the lobbying activities of the registrant, and approximate percentage of equitable ownership in the client, if any, of any foreign entity that A. Holds at least 20% equitable ownership in the client or any organization identified under paragraph 3. B. Directly or indirectly, in whole or in major part, plans, supervises, controls, directs, finances, or subsidizes the activities of the client or any organization identified under paragraph 3, or C. Is an affiliate of the client or any organization identified under paragraph 3 and has a direct interest in the outcome of the lobbying activity. 5. A statement of A. The general issue areas in which the registrant expects to engage in lobbying activities on behalf of the client, and B. To the extent practicable, specific issues that have, as of the date of the registration, already been addressed or are likely to be addressed in lobbying activities. 6. The name of each employee of the registrant who has acted or whom the registrant expects to act as a lobbyist on behalf of the client and, if any such employee has served as a covered executive branch official or a covered legislative branch official in the 20 years before the date on which the employee first acted as a lobbyist on behalf of the client, the position in which such employee served, and 7. For any listed lobbyist who was convicted in a federal or state court of an offense involving bribery, extortion, embezzlement, an illegal kickback, tax evasion, fraud, a conflict of interest, making a false statement, perjury, or money laundering, the date of the conviction and a description of the offense. No disclosure is required under paragraph 3b if the organization that would be identified as affiliated with the client is listed on the client's publicly accessible internet website as being a member of or contributor to the client, unless the organization in whole or in major part plans, supervises, or controls such lobbying activities. If a registrant relies upon the preceding sentence, the registrant must disclose the specific internet address of the web page containing the information relied upon. Nothing in paragraph 3b shall be construed to require the disclosure of any information about individuals who are members of, or donors to, an entity treated as a client by this chapter, or an organization identified under that paragraph. C. Guidelines for registration. 1. Multiple clients. In the case of a registrant making lobbying contacts on behalf of more than one client, a separate registration under this section shall be filed for each such client. 2. Multiple contacts. A registrant who makes more than one lobbying contact for the same client shall file a single registration covering all such lobbying contacts. D. Termination of registration. A registrant who after registration 1. Is no longer employed or retained by a client to conduct lobbying activities and 2. Does not anticipate any additional lobbying activities for such client, may so notify the Secretary of the Senate and the Clerk of the House of Representatives and terminate its registration. 2 U.S. Code paragraph 1604, reports by registered lobbyists. A. Quarterly report. No later than 20 days after the end of the quarterly period beginning on the first day of January, April, July, and October of each year in which a registrant is registered under Section 1603 of this title, or on the first business day after such 20th day if the 20th day is not a business day. Each registrant shall file a report with the Secretary of the Senate and the Clerk of the House of Representatives on its lobbying activities during such quarterly period. A separate report shall be filed for each client of the registrant. B. Contents of report. Each quarterly report filed under subsection A shall contain 1. the name of the registrant, the name of the client, and any changes or updates to the information provided in the initial registration, including information under Section 1603(b)(3) of this title. 2. For each general issue area in which the registrant engaged in lobbying activities on behalf of the client during the quarterly period. A list of the specific issues upon which a lobbyist employed by the registrant engaged in lobbying activities, including, to the maximum extent practicable, a list of bill numbers and references to specific executive branch actions. B. A statement of the houses of Congress and the federal agencies contacted by lobbyists employed by the registrant on behalf of the client. C. A list of the employees of the registrant who acted as lobbyists on behalf of the client. And D. A description of the interest, if any, of any foreign entity identified under Section 1603(b)(4) of this title in the specific issues listed under subparagraph A. 3. In the case of a lobbying firm, a good faith estimate of the total amount of all income from the client, including any payments to the registrant by any other person for lobbying activities on behalf of the client during the quarterly period, other than income for matters that are unrelated to lobbying activities. 4. In the case of a registrant engaged in lobbying activities on its own behalf, a good faith estimate of the total expenses that the registrant and its employees incurred in connection with lobbying activities during the quarterly period. 5. For each client, immediately after listing the client, an identification of whether the client is a state or local government, or a department, agency, special purpose district, or other instrumentality controlled by one or more state or local governments. And 6. For any listed lobbyist who was convicted in a federal or state court of an offense involving bribery, extortion, embezzlement, an illegal kickback, tax evasion, fraud, a conflict of interest, making a false statement, perjury, or money laundering, the date of the conviction and a description of the offense. C. Estimates of income or expenses for purposes of this section. Estimates of income or expenses shall be made as follows. 1. Estimates of amounts in excess of $5,000 shall be rounded to the nearest $10,000. 2. In the event income or expenses do not exceed $5,000, the registrant shall include a statement that income or expenses totaled less than $5,000 for the reporting period. D. Semi-annual reports on certain contributions. 1. In general, not later than 30 days after the end of the semi-annual period beginning on the first day of January and July of each year, or on the first business day after such 30th day if the 30th day is not a business day. Each person or organization who is registered or is required to register under paragraph 1 or 2 of Section 1603(a) of this title, and each employee who is or is required to be listed as a lobbyist under Section 1603(b)(6) of this title or subsection B(2)(c) of this section, shall file a report with the Secretary of the Senate and the Clerk of the House of Representatives containing A. The name of the person or organization. B. In the case of an employee, his or her employer. C. The names of all political committees established or controlled by the person or organization. D. The name of each federal candidate or office holder, leadership PAC, or political party committee, to whom aggregate contributions equal to or exceeding $200 were made by the person or organization, or a political committee established or controlled by the person or organization within the semi-annual period, and the date and amount of each such contribution made within the semi-annual period. E. The date, recipient, and amount of funds contributed or disbursed during the semi-annual period by the person or organization, or a political committee established or controlled by the person or organization. 1. To pay the cost of an event to honor or recognize a covered legislative branch official or covered executive branch official. 2. To an entity that is named for a covered legislative branch official, or to a person or entity in recognition of such official. 3. To an entity established, financed, maintained, or controlled by a covered legislative branch official or covered executive branch official, or an entity designated by such official, or 4. To pay the cost of a meeting, retreat, conference, or other similar event held by, or in the name of, one or more covered legislative branch officials or covered executive branch officials, except that this subparagraph shall not apply if the funds are provided to a person who is required to report the receipt of the funds under Section 30104 of Title 52. F. The name of each Presidential Library Foundation and each Presidential Inaugural Committee, to whom contributions equal to or exceeding $200 were made by the person or organization, or a political committee established or controlled by the person or organization within the semi-annual period, and the date and amount of each such contribution within the semi-annual period, and G. A certification by the person or organization filing the report that the person or organization 1. Has read and is familiar with those provisions of the standing rules of the Senate and the rules of the House of Representatives relating to the provision of gifts and travel, and 2. Has not provided, requested, or directed a gift, including travel, to a member of Congress or an officer or employee of either House of Congress with knowledge that receipt of the gift would violate Rule XXXV of the standing rules of the Senate or Rule XXV of the rules of the House of Representatives. 2. Definition. In this subsection, the term leadership PAC has the meaning given such term in Section 30104 I-8b of Title 52. E. Electronic filing required. A report required to be filed under this section shall be filed in electronic form, in addition to any other form that the Secretary of the Senate or the Clerk of the House of Representatives may require or allow. The Secretary of the Senate and the Clerk of the House of Representatives shall use the same electronic software for receipt and recording of filings under this chapter. 2 U.S. Code Paragraph 1605, Disclosure and Enforcement. A. In general, the Secretary of the Senate and the Clerk of the House of Representatives shall 1. Provide guidance and assistance on the registration and reporting requirements of this chapter and develop common standards, rules, and procedures for compliance with this chapter. 2. Review, and, where necessary, verify and inquire to ensure the accuracy, completeness, and timeliness of registration and reports. 3. Develop filing, coding, and cross-indexing systems to carry out the purpose of this chapter, including a publicly available list of all registered lobbyists, lobbying firms, and their clients, and b. Computerized systems designed to minimize the burden of filing and maximize public access to materials filed under this chapter. 4. Make available for public inspection and copying at reasonable times the registrations and reports filed under this chapter and, in the case of a report filed in electronic form under Section 1604 (e) of this title, make such report available for public inspection over the Internet as soon as technically practicable after the report is so filed. 5. Retain registrations for a period of at least 6 years after they are terminated and reports for a period of at least 6 years after they are filed. 6. Compile and summarize, with respect to each quarterly period, the information contained in registrations and reports filed with respect to such period in a clear and complete manner. 7. Notify any lobbyist or lobbying firm in writing that may be in non-compliance with this chapter. 8. Notify the United States Attorney for the District of Columbia that a lobbyist or lobbying firm may be in non-compliance with this chapter, if the registrant has been notified in writing and has failed to provide an appropriate response within 60 days after notice was given under paragraph 7. 9. Maintain all registrations and reports filed under this chapter, and make them available to the public over the Internet, without a fee or other access charge, in a searchable, sortable, and downloadable manner, to the extent technically practicable, that a. Includes the information contained in the registrations and reports, b. Is searchable and sortable to the maximum extent practicable, including searchable and sortable by each of the categories of information described in Section 1603(b) or 1604(b) of this title, and c. Provides electronic links or other appropriate mechanisms to allow users to obtain relevant information in the database of the Federal Election Commission. 10. Retain the information contained in a registration or report filed under this chapter for a period of 6 years after the registration or report, as the case may be, is filed, and 11. Make publicly available, on a semi-annual basis, the aggregate number of registrants referred to the United States Attorney for the District of Columbia for non-compliance as required by paragraph 8. B. Enforcement Report. 1. Report. The Attorney General shall report to the congressional committees referred to in paragraph 2, after the end of each semi-annual period beginning on January 1st and July 1st, the aggregate number of enforcement actions taken by the Department of Justice under this chapter during that semi-annual period and, by case, any sentences imposed, except that such report shall not include the names of individuals or personally identifiable information that is not already a matter of public record. 2. Committees. The congressional committees referred to in paragraph 1 are the Committee on Homeland Security and Governmental Affairs and the Committee on the Judiciary of the Senate and the Committee on the Judiciary of the House of Representatives.